Let me define abuse for you. It's important. According to the Wisconsin statutes, any single or repeated act of force, violence, harassment, deprivation, neglect, or mental pressure which reasonably could cause physical pain or injury or mental anguish or fear. That's a mouthful of a definition, but again, it covers the conscious or unconscious piece of taking care of your client. Abuse can be physical, it can be verbal, it can be emotional, perhaps the person's afraid. It can even be subtle. And we're going to talk about subtle abuse in just a bit. Let me first give you some examples of abuse. Although life can be taxing and your day might be stressful, yelling at a resident is considered abuse. It's inappropriate, it's not respectful, it's not preserving their rights. Hitting a resident, likewise, is considered abuse. Another example would be ignoring a resident while giving another resident extra attention, maybe because you find them more pleasant to care for. That would be a situation of subtle abuse. It's not real obvious, but you are treating them differently, the two residents or the two patients, the two clients. Another example of abuse would be making promises you don't intend on keeping. Perhaps you tell Mrs. Jones, yes, I'll come back with the pictures of my grandchildren. And truly in your mind you're thinking, I'm not going to come back later today with those pictures to show her. It's abusive to make that promise and then not to give that to her or share that with her. It's subtle abuse. So be it sharing something personal of your own or coming back to help her with something, or even telling her you'll be back to help toilet her. Those are all forms of subtle abuse if you don't intend on keeping them. Getting even with the resident is also considered abusive. How do you do this? It may be something like making a resident or a patient wait for care. Maybe making them wait to be toileted. It may be withholding a favorite food or not answering their call light. That's abusive. Leaving a resident in wet or soiled clothes is an excellent example of abuse. We all get busy. But doing this as a punishment for incontinence or leaving them longer than you could get to them to assist them is considered subtle abuse. Facial expressions or gestures of disgust, perhaps you roll your eyes at a patient or roll your eyes as you walk away from them, that's subtle abuse, as is indifference or acting as though you don't care. Finally, an example that hopefully doesn't happen in your facility, but again is construed as abuse, is making fun of a resident. It's inappropriate, it's disrespectful. I share these examples with you because legally you are being held to the standard of not abusing your resident or your patient either overtly or subtly. So you need to know that these are all considered abusive. In fact, you are asked to provide reasonable care. Reasonable care can be defined as care that is given at a level that is equal to care given by another worker of comparable level of experience under similar circumstances. So it's comparing you against others in a similar situation. Failing to meet the definition of reasonable care is construed as abusive. Informed consent is one way to make sure that you're providing the care that your resident or your client expect. Informed consent is an agreement or contract between yourself and the person that you're providing care to. The client must be of sound mind, 18 years of age, without alcohol impaired or drug impaired thinking, and must be mentally competent to know what is to be done as well as the consequences of doing the action. So if you're not sure and you want to protect against something being perceived as abusive, ask for consent. An example might be bathing. Asking your resident if it's okay to bathe them. I've even heard of residents in facilities being asked by a caregiver, can I touch you? Is it okay for me to hold your hand? Can I give you a hug? asking for informed consent from that person to make sure it's okay with them. Best way to make sure you're doing what your client wants. In terms of a client expressing their wishes to you, in addition to informed consent, there are some formal documents that are used. One of them being the last will, the other being the living will. Let me touch on both of these for you so you understand the importance that they have and the need to respect and follow them. Wills are a mean of informing other people of their wishes, both types, informing others of their wishes. The last will is a means of communicating how you want your personal affects, that shawl that meant a lot to you, those pictures in the room, whatever it might be that's personally yours, as well as financial resources. So what you want done with those things. Keep in mind that you may witness a will so long as you're following facility policy. So ask. And so long as you are confident that the person that is signing it is of sound mind and able to give, again, their informed consent. So you are able to do this per your facility's policy. So do ask. It varies amongst facilities. On the flip side, you should never help to prepare a will. That's a legal issue. And in the case that someone asks you, if a request is made, what you can do is communicate this request to a supervisor and let them coordinate the request with the patient. Usually they'll contact a legal representative. So that's something that we as caregivers should never be doing. Living wills are different than last wills. Living wills is a tool to communicate what you want to have done when you can't speak for yourself. A living will indicates whether a person wants, for example, life support, wants to be tube fed, other life support devices should circumstances arise. And those, again, are ways that someone would communicate their wishes. Legal standards are in place to preserve the rights of our client as well as to prevent against abuse. Legal standards are also called laws. And their written expectations are how you are to behave as well as consequences for failing to behave in an expected way. Now, my role in this lesson is not to act as a legal counselor because by no means am I a lawyer. However, it's just to introduce you to the legal standards you will be held accountable for upholding your role as the caregiver.